forward. Yeah, this webinar will be recorded, and the slides from Michael's presentation will be on autopaycheck.com/blog. And you can have it, you'll see it up there this afternoon. I'll also send it out in an email, so you'll get it in a couple of different ways. Please remember to keep yourself muted. We want to keep the background noise to a minimum so we can hear all of what Michael has to say. If you do have questions, which we love questions, please go ahead and open up your chat function, and I will monitor those and read them off to Michael as they come in. So if you have any questions, if we don't get to your question in this presentation, you can always follow up with Michael. His contact information is on the slides, and if you need to reach out to me or out of paychecks, you can get in touch with us as well. So without further ado, Michael Santo has been practicing law, he's been practicing law since 1992 after receiving his undergraduate degree from Michigan State University and his law degree from University of Detroit. He's focused his practice on defending companies in employment litigation, including sex, race, age, national origin, religious and disability discrimination lawsuits, wrongful discharge, and wage and hour matters. He regularly represents employers in prosecuting and defending claims of trade secret misappropriation, unfair compensation, or employee rating. He constantly is counseling companies on day-to-day employment issues.
I think I just constantly give some. I'm not really sure. So, yes.
Yeah, important part of his practice. And this includes advising employers on hiring, discipline, and termination decisions on leave and disability issues, and on preparing and revising employee handbooks. I know Auto Paychecks relies on Auto Paychecks and his expert advisement, and we refer all of our clients to him and his practice. So he has been very generous in sharing what he knows, and I look forward to what he has to tell us today. I got a little sneak peek at his presentation, and I know he's going to touch base on updates to employment discrimination law, the Colorado Secure Savings Program, so that retirement program, employment arrangement or agreements, unemployment insurance, and whatever else he can fit into the next hour. Again, please submit your questions through chat, and we will address as many of them as possible. I'm going to go ahead and start sharing his presentation and let him take over.
Yay, good morning, everyone. Please let me know. No, I'm second.
I'm not sharing it yet. I got ahead of myself.
Yes, it was.
Okay, now you've got it.
Good morning, everyone. Can everyone hear me okay? I saw some people, the phone was a little bit away from Manon, so that may be why people couldn't hear many things. If you can't hear me, I rarely get, hey, Michael, could you please speak up? But I guess it's always possible. Good morning. Okay, so what we are here today to do is to go over the end of the legislative term. What's out there, what came in. There was a lot of efforts that did not pass, and a number that are still sitting on the governor's desk. My expectation, and in talking with those in the know, is that all these bills we're going to cover that are sitting on the governor's desk will be signed in the near future. So I don't anticipate hearing any veto of any of the employment bills we're here today to discuss. In fact, a couple of them, one in particular, really snuck through in terms of I didn't see it up on signed by the governor. We'll talk about that with respect to the new unemployment for a couple of days. So yeah, let's get started. And we're going to go back to 2020 just simply because of this quick overview we're going to do of the retirement fund. I'm sure there's a million copyright violations that I'm not supposed to use Mr. Bill, but he's just too adorable to pass down. So where are we in the legislative term? Well, we ended in mid-May, and under our Constitution, that the governor now has 30 days within which to sign his bill or the bills that are in front of him. which means some of these are quickly sneaking up. We should know within the next week or two whether or not he signs all of them. Frankly, I think he's going to sign, as I said, all of them will be signed by the end, maybe the end of this week, certainly the end of next week. All the bills that we're talking about that haven't been passed. Do you have a question already?
Not yet, not yet.
Yo, you looked at me like I have a question. I was like, is it on the cute little bill thing? The governor, if it's delivered in the term, then he's got 10 days. If it doesn't, then it's 30 days. So that's where we are. What did we get this year? It's odd to start off with what bill didn't we get this year, but there were some really big bills that didn't go as far as we thought they would. For example, one of the big bills in 2020 was Colorado HIFWA, the Colorado Healthy Families and Workplaces Act. That one passed in 2020, started to take effect for larger organizations in 2021 with respect to the sick leave, started to take effect with respect to the public health emergency leave for all employers on January 1, 2021. And then small employers got covered by the sick leave portion of it on January 1, 2022. The bill that was proposed would have reverted the law back to say that small employers are not covered by the sick leave portion of HIFWA. And it was not, I didn't think it had a chance. It stuck around a little longer than I thought it would. But for those who were keeping track of it, it did not pass, and small employers remain covered by HIFWA. So all of you small employers out there with under 16 employees who were saying, please say it passed, please say it passed. It did not pass. You're still covered by HIFWA. Sick, you've of course been covered by HIFWA public emergency since January 1, 2021. What happened? Is it you? There we go. By far the biggest bill that got, I think, the most publicity was the prohibit adverse action for marijuana usage. That one, it was, woo! So that would have been a lot of fun. It basically permitted employees on their now constitutionally guaranteed rest breaks the ability to smoke on the premises. It would have been an interesting bill had it passed. It did not get very far, but let me tell you, of all the bills that got proposed, it was the one that I got the most questions on until it was finally postponed indefinitely. The other one, and we'll talk about this a little bit at the end, man, and I know your group just recently put on a talk about FMLAI, FAMLI. So the Democrats, I think someone's not on mute or something. The Democrats proposed, many thought with the governor's approval, a bill that would have basically created a 6-month gap before employers had to start paying contributions for family. So not until mid-2023. That did not pass. So keep in mind, and we'll talk about this at the end, family goes into effect in terms of the withdrawals, the withholdings, January 1, 2023. I have not seen anything on the lawsuit that was filed with respect to it. It was filed actually by a local grand junction company claiming that family is in essence a tax, which would be a violation of TABOR. That was not approved, that was rejected by the district court. It immediately went to the Supreme Court, and we await a Supreme Court decision. I have not seen anything on that. But I expect that to be sometime maybe in the fall. We're going to get into this in a second. The Power Act was by far the big act of 2021. HIFWA dominated 2020. Power Act dominated 2021 in terms of the massive changes to discrimination laws, the basically providing employees a claim if organizations did not investigate workplace complaints. Of course, expanded out what exactly does it mean to have a workplace complaint. And there were a number, and the one that garnered, I think, all the publicity was the claim employees would have had for feeling disrespected at work would have immediately provided employees a claim. We anticipated that coming in 2022. Everyone I talked to said they're going to give another try at it. They really did not. We got a very streamlined version of it, and that is this bill here. There are changes that were in power that have now been transferred over to this bill, but as I said, just really the smaller portions of power. In particular, it's going to expand the definition to include individuals in domestic service. So there was an exception to that in the Colorado Discrimination Act. It specifically said employees do not include those in domestic service. They have removed that. So from here forward, those individuals will be covered by the Act. One of the interesting things that is, you may say, well, we don't have any domestic service employees. We're a law firm. We're a auto paychecks. We're an accounting place. We don't have any domestic service employees. Yes, but do you have employees who are also employed in domestic service, who are also doing domestic service after their employment as a side career or side business? So something we've been encouraging organizations to tweak their handbook just a little bit. There's a bigger tweak coming down the road. We'll talk about in a second. But just to identify that it does cover those employed in domestic services as well.
I know about that.
Yeah, that was one of the smaller changes. One of the bigger changes is something that's always been confusing, which is we have, of course, in Colorado, two separate groups that investigate discrimination claims, harassment claims, retaliation claims. And those are, of course, the EEOC, Equal Employment Opportunity Commission, and the Colorado Civil Rights Division. What Colorado Civil Rights Division is only for those with, no, it can be, I should say, let me flip that around. The EEOC is only for those with 15 or more employees, or 20 or more if it's an age discrimination claim. Colorado Civil Rights can cover anyone else, but they tend to focus on smaller employers. 10, not only. But there were different time periods for employees. One, Colorado Civil Rights, you had to file within 6 months. EEOC, you could file within 300 days. So it was not, they were not the same, and it kind of created some problems, and they just mushed them together. And so that means for smaller employers now, for larger employers, the change is almost infinitesimally small, a little bitty. For smaller employers, it is a big change because now you go from having a 6-month time period for your employee to be able to file a claim to 300 days. So they've expanded that out for small employers. Let's see. Oh, there is a time period within which Colorado Civil Rights, for those of you who've gone through one of these processes, that's okay. One of these processes, they have traditionally been given 270 days to complete Colorado Civil Rights, to complete their process. And, you know, if you want a hearing, you've got 270 days. That just got up to 450 days. So it's now, and for attorneys, by the way, can I go on record? 450 days is really super fast. So I know everyone else is kind of laughing at that, but for us, that's like lickety-split. So they've moved that request for a hearing up. As identified here, it passed May 9th. It did not get to the governor's desk right away. It took some time, but that's when it passed the Senate and the House. So it is currently sitting on the governor's desk. I do anticipate that he will sign it. Along those lines, the EEOC, and I think this is what Colorado was somewhat piggybacking on, the EEOC has been issuing caregiver guidance for They're individuals, employees who act as caregivers for their families and friends and may be protected by current anti-discrimination laws. So keep in mind that in particular, that can be a disability claim. So when you have an employee make a reasonable accommodation request, hey, I need to take care of my mother, I'm going to be gone in the mornings from now, and can I come in at 9, or can I come in at 10, can I come in a little later? The EEOC, or can I miss Thursdays? The EEOC is looking at that as that is something protected. It's not for smaller, now you may say, well, yes, of course, that's covered under FMLA. But for smaller employers who aren't covered by FMLA, this may also provide those employees some rights as well. So when you get employees' requests for time off, particularly time off for family members, make sure you're considering it from the standpoint that the EEOC is now looking at it as protecting caregivers as well.
Nobody needs to work.
Okay. I appreciated that comment. So let's see. This is the one, I'm not gonna lie, it slipped through in 2020. I don't know what I was doing in 2020, some pandemic or something, that somehow it slipped through. It's for, this is the one Manon mentioned at the beginning, it's called the CARA, Secure Savings. We are going to be getting rules about this in the near future, as you'll see in a sec. But it's basically what they determined is nearly a million or just over a million Colorado employees are not enrolled in any kind of retirement program, any kind of 401k, any kind of simple IRA, anything. They are going along. And so what Colorado did is they implemented this secure savings program that is going to take effect in 2023. And so, but as you'll see in a second, I think it's the next one. We're going to start, yeah, it's the second slide. We're going to start getting all of our rulemaking in July 2022. So for those of you who say, I got questions about how this is going to work, and I have questions about how that's going to work, really hold off till July 2022. Maybe we should come back with another talk in August once those get finalized. But right now, they are, there's been a little information available, but not a ton. In essence, if you employ 5 or more employees, you've been in business for 2 years, and you're not offering any workplace retirement program, there's going to be this program that your employees are going to have to enroll in. Good news is, there's going to be no fees for doing this. You're not going to have any fiduciary liability. So it's going to be no employer matching contribution. It's simply basically forcing the employee to start saving, those million employees to start saving some money.
Is there, like, how is it administered? Is it up to the employer, or do we know yet to offer that program, or is the state going to be contacting employees directly?
It's the way I read it, and mostly this is from the law, is going to be up to the employer to make sure that all their employees, when they know we don't offer a 401k, let's say, we don't have an IRA, we've got nothing. We have over 5 employees. We've been employed 2 years. By the way, we actually do offer. So, but if you don't, what you're going to have to do is make sure you get out to employees this information about, hey, come 2023, I'm going to have to start deducting from your pay for these amounts.
So it's not voluntary for those employees?
No, you're going to have to, have to do it.
Okay.
So, yeah. That's why we're so anxious. As you see, employers can face penalties such as failure to enroll of $100 per employee per year, or up to a maximum of $55,000 annually.
We do have a question. If you offer 401k, do employees have to participate?
No. In fact, you don't have to do it at all. It's only for those who have no retirement. And just so we're on the same page, vacation is not really a retirement account. So make sure that, speaking of that, have you guys gotten, I'm going to ask my own question here. Speaking of vacation, have you guys seen an increase of concerns expressed about vacation buyback programs?
I mean, it's definitely more of a conversation when we bring on new clients predominantly, of understanding, you know, now it's not just vacation that you have to have, but PTO, you know, all PTO. And what does that mean as far as at the end of the year? Is it, you know, can we cap? Can,
Okay, yeah, those are very different things.
yeah.
We've been seeing a lot more questions on this, and this isn't a legislative part, and I've meandered off down the road for a second, but we've been seeing a lot of conversations about constructive receipt. For those who have a buyback program, or payout, or cash out, whatever you wanna call it, not necessarily end of the year, make sure you're talking to your accountant about the constructive receipt rules of vacation cash outs. The more relaxed those procedures are, the more I've been hearing from accountants the need to start, in essence, taxing those vacation banks, even though they're not used, because of a constructive receipt. There's a lot of good publications out there. So, but when vacation pay came up, I didn't know if you guys were seeing that as frequently as we are.
But we do get a lot of questions, or a lot of people not understanding constructive receipt. So that's not necessarily when the time was earned, but when it's received by the employee. So
Right.
if it's earned in 2022 and paid out in 2023, January 1st, it's taxed in that year.
Or is it, and then you get those who, they're trying to say, like, if I never pay it out in 2023, but you and I are the same company, you take the cash out, I don't. I still get taxed on my balance because the way the company's rules are set up, make the vacation look like more of a bank account. I can just pull money from it whenever I want. I don't have any rules. So make sure if you've got one of those, the vacation payout, that it's got really loose rules, like, hey, whenever you want it, you can get it. Make sure you're talking to your accountant, because they may have some tax implications. Sorry, okay, so upcoming deadlines.
We do have a question, if that's okay.
On the vacation or the, hit me, I'm ready.
This is about the retirement program. So this is from Joni. What about those that already have a savings or are contributing to an IRA or a program that they being required to contribute it out of their paycheck?
Yeah, if it's coming through the employer, you should be good, because it's been sponsored by the employer, it's put in place by the employer. They want to see some money flowing to IRAs, as I understand it, 401ks, who knows? Yeah.
And then this is a good question. So if the company has a 401k program, but the employee is not participating, do they have to automatically participate in the state program? I
give away something, that's a really good question. We are going to, for those of you who don't get our newsletter, we do much more frequent newsletter these days. We don't do quarterly anymore. The law kept changing on us. And so we will answer that question in an upcoming newsletter. It's a great question. I don't know the answer to that.
Right. And then does this apply to part-time employees?
Yeah, it's going to apply. Yeah, that's what as I understand the bill. Now, mind you, the parameters of the law were typically very broad. Now we're going to get, in July, we're getting the final rule. So a lot of these questions are going to be answered in August, and we'll have something on that as well, as I'm sure you guys will. So if you have, let's go to the next one, restrictive employment agreements, non-compete agreements. They have really changed non-compete agreements. And, you know, in the old days, we always said, oh, they're totally not enforceable. No, they are enforceable. It does start with typical law stuff about the non-compete agreements are void, but then the law says, but there are exceptions. So, for example, you can have an agreement with one of your employees. Hey, man, we're going to send you off to training. It's going to cost us $10,000 for this training. You're going to get trained in all this. You've just started with the organization. I can have a non-compete agreement as the organization to say, well, Manning, if you leave within 2 years of employment, not 2 years after the training, your first 2 years of employment, I can get that money back from you that I spent on the training. And if you don't pay it back, you're going to be subject to a non-compete. So you can't get the training from me and then go across and work for my competitor, because it just cost me all this money. So for those organizations who do a lot of training in their first couple of years, something to consider, because the new law permitted this as well. Now, it isn't in-house training. Mentoring and those kind of things are not covered by the law. So if I say, well, man, and I've spent 20 hours this week, so that means since you're leaving, you owe me this back. No, it doesn't work there. It's got to be a training program that the person's engaged in, and so you can get a non-compete agreement for there.
That's interesting.
Yeah. Let's see. Oh, they changed the non-compete. And for years, it has been, is the individual a manager or officer of the organization? Now they've gone to an annual cash compensation. So now if you want a non-compete agreement over certain employees, they've got to be, I always forget the number, it's like 106,000. If they're under 106,000, that is not enough, and those individuals not going to be able to get a non-compete with them. So it went from managers or officers to this really high threshold.
It's always interesting what number they end up picking, like why not just 100,000, 106, but.
I think they were trying to mirror it to the weirdest one with that is computer professionals who have to get paid $27.63, which is, don't ask me where they came up with that. But I think they wanted it to go along with the highly classified exemption under the Fair Labor Standards Act. They were trying to somewhat mirror that.
Okay. And we do have a question about this. I'm trying to move closer so you can hear me better. When are these changes going into effect?
So the governor has not signed these yet. Once he signed, what happened there? It will be within 90 days. That was me.
Okay.
It will be within 90 days of that. I expect him, I don't think he's required to see it went 5-10. I think it took a little bit. I bet we get it within the next 7 to 10 days, but they're not going in, and it will change your current agreement. So for those who are saying, sweet, I got in just under the wire. No, you're gonna have to change your agreements as well. So make sure that you're changing those to reflect the new amounts.
No grandfathering.
No grandfather, you didn't sneak in under the wire. There's a lot of requirements, I don't have this in here, I don't think I do, but there's a lot of requirements, oh, here it is. Where am I? Where did I go? Mine's different. Oh, it's here. It can't be in the handbook. So for those of you who have it in your employee handbook, it's got to be pulled out. It's got to be clear and conspicuous. You have to give your employees time to review it. So current workers have to get it at least 14 days before the effective, or if you decide to offer additional compensation, at least 14 days before that. And Manon will send out all the materials, as she said, because I'm bouncing around on these. So and if you're going to do it with a new employee, as it identifies here, it has to be given prior to employment. So like part of the offer letter. Attached to the offer letter, since don't forget it has to be separate and apart.
Right. So if I have a signed agreement from an employee and they cannot work for another company in the same industry, I have to have them sign another agreement for it to be valid after the governor signs.
Yeah, I would do that. I would be concerned because the exceptions you were going under when you signed that agreement are no longer going to be the exceptions. I think that would be, you make an argument all you want, but I think to be more conservative, I would definitely get the individual to sign again.
Okay.
If you have a physician practice, don't forget the same rules with physicians still apply. It's still, the non-compete agreements with physicians are basically impossible. You have to do it as another way. One of the interesting things for those of you who are statewide companies, where did I have this? If you have a statewide company and you say, hey, we're going to make the jurisdiction in Connecticut because we know that's very pro-employer, and frankly, it's going to be really hard for the employee to litigate on Connecticut. Like the next time you read your Apple agreement, look to see where Apple has all of us bringing the litigations, because it's kind of funny. that will not be valid anymore. We now need to change that jurisdiction back to Colorado. So make sure if you've got a choice of law provision in your agreement, that the choice of law provision identifies it as Colorado.
I did have a question. Will I be sending something out when the governor signs? I'll watch for it. Michael Santo, his newsletter is going to be your best resource on that. So if you're not signed up for his newsletter yet, go ahead. I know we have a link to sign up for that on our blog.
Oh, good.
But I will make sure that I send another one out as well. So that I would watch for news from him.
We've already got the articles written.
Yeah.
We're just waiting for the governors to sign, governor to sign them. One of the weird things that came up, and I always tell the story of the person, I don't remember who the person was because it was back in probably 1995, and I can barely tell you what I had for breakfast, much less a specific conversation in 1995. But in 1995, I remember a client called me and was asking me to, hey, I want to put together a non-compete for my employee. And I said, we went over everything, and I said, well, you're not covered by any of the exceptions to the law. There's no way you could enforce this agreement. And I remember the client saying to me, okay, so you know that, and now that you've told me, I know that, but the employee doesn't know that. So while I technically can't enforce it, aren't I probably going to get some benefit because they think they're covered? So there's a new criminal bill came in, and a lot of people believe that it creates criminal liability for knowingly using a non-compete agreement that violates Colorado's non-compete law. So in essence, the Senate Bill 2021-271, which is primarily geared toward reforming sentencing of misdemeanors, did talk about a person who violates 82113 commits a Class 2 misdemeanor, punishable up to 120 days in jail, fined of up to $750, or both. So if you've got one of those agreements out there and you're thinking, well, it's a really difficult bill to read, or it's really long, which it is. It's the second longest bill, I think, of the employment variety this year. They're not going to read it. It'll be fine. Keep in mind that this new law creates criminal liabilities for even having the agreement, perhaps. Not even so much enforcing the agreement, but perhaps even just having the agreement. And since I don't do criminal law, please don't be careful on that. Be very cautious for those. So, jump quickly to federal law before we get to really the big law of the session, which is a couple of years ago, all the rage became arbitration agreements. We want arbitration agreements. It's so much better. I'm not going to get into why I don't think that. But, and employers were covering everything by non-compete agreements that they could. That was until this year. The Congress actually somehow agreed to what day of the week it was and put a bill before President Biden, and he signed it, which has removed sexual assault and principally for employers sexual harassment from being subject to arbitration. So from here forward, if you have an arbitration agreement with your employee, keep in mind you're going to have limited rights to enforce it. It went into effect immediately. If you signed it before, that's the way it goes. You can still enter into one, but keep in mind the employee may decide after the claims arrive, I don't want to go to arbitration. So keep in mind that even if you have an agreement, even if the employee signs it after this went into effect, it still has the, that came off the screen. Oh, sorry. It's on the screen when you get the materials. That it will be now, the employee will have their option of whether or not, if they have an arbitration agreement, it goes to arbitration or it goes to court. What's the big bill? The big bill with by far the big change was the Restore Unemployment Bill. I think this is the first one, or did I take out the first one? This is the first one. they tried this early in the year, as in case you haven't heard, we have an unemployment deficit problem. We are currently, or we were at the time, about $1.1 billion in the red with respect to our unemployment compensation fund. And what this bill proposed is sending a whole bunch of money to the unemployment fund. I've been told that what happened was, while this was proposed, not being political, just telling you who eventually came up with the other bill, which is Democrats wanted more changes to the unemployment statute than this bill did. Knowing that we needed money, it was an opportunity for the fund. Knowing that it was an opportunity, they seized upon the opportunity, made a number of changes to the unemployment statute. So this one just did the unemployment transfer of $1 billion over to $1.1 billion to the general fund. The other one, this is the new one, and this is the one that did pass, and it put $600 million toward state unemployment. Plus, it talks about an insolvency surcharge that we're all going to be paying until we fill that $1 billion hole. So, any partial unemployment benefits during COVID, there was this spike in partial unemployment benefits. They made that now permanent, so people are going to get more benefits when they are on partial unemployment. And it used to be that you had to wait a week before. They've now removed that. So individuals are going to become eligible for unemployment super duper fast. By far the biggest one is this one. And that is, and it goes hand in hand with something that I thought I had in here, but we're going to see. If not, I can cover it. There was a change in 2020 that required organizations to provide notice to their employees about an opportunity to receive unemployment benefits. That employees, we're supposed to let all the employees, if you haven't, you should let all your employees know. Where does that have to come? It could be an employee handbook, could be in a termination letter, could be maybe as part of a poster, but we had to let employees know at the time of separation about the opportunity to file unemployment benefits. They've upped that, and now we must provide at the time of separation we have to give the employer's name and address. So if you, I guess, write it on your letterhead, that would seem to solve that problem because it's got your name and your address on there. You also have to let the employee know their name and address. Not really sure why they don't know their name and address, but you have to tell them their name and address. You also have to tell them their identification number, that's with the organization, or you have to tell the employee the last four numbers of their Social Security card. So there's been a lot of speculation as to exactly why that is. One of my speculations was that this new unemployment statute made it easier for unauthorized workers to get unemployment benefits in the state of Colorado. And I often wondered if perhaps it was something to unauthorized workers who maybe didn't use a legit Social Security number, that you now need to identify that number so that they have that. I don't know. I'm just massively speculating as to what the reason to tell an employee their Social Security number. You also have to let the employee know their start date, their last day of work, their year-to-date earnings, and how much wages the employee earned. The last two things I would think would be on most of your paycheck stubs, which would solve the problem. I've been trying to figure out a way to write this smoothly. It feels wonky. You can do it as an attachment. Maybe that's easier, just have a little attachment with things and fill that in. It doesn't have to be in the term letter. You could also just refer, for the last two, just to your pay stubs.
I mean, really, date of last day worked, year-to-date earnings, and wage for the last week of unemployment would all be on your final pay stub.
You would assume.
Right.
But if not, here's the big one though, which is not gonna be on your pay stub, which is the reason the employee separated from, the employer. We have to identify the reason that the employee is separating, and some of you may be saying, hold on a second. Colorado is an employment at will state. Even though Michael, and I think you guys do as well, even though you guys advise us to do reasons for termination, we don't gotta under the law. It says employment at will. We've been employment at will since like we were a state. What is this? Yeah, unemployment doesn't care. This is, you now need in some document that's given to the employee, you now need to give the reason for separation, which looks a little inconsistent with at will employment, but what I've been trying to advise organizations to do is consider, if you want to do like a checkbox, which would be, which would mirror unemployment. Because at unemployment, you're going to be telling people the reason why they separated. So really all you're doing is putting that in a little bit early now. So keep in mind that's out there as well. The trick, and it'll be interesting, CDLE, Colorado Department of Labor, I think, you know, I give them a hard time quite frequently, but I think they've done a nice job with their interpretive notices. For those of you who aren't on that site, I really encourage you to have that site bookmarked because there's good information on them coming out from the Department of Labor. I don't always agree with it, but it's good information. Yeah.
We have two questions
Two
about
questions.
the same thing.
What's the penalty?
Well, no.
Oh.
Is this for voluntary and involuntary?
That's the trick. Well, I was talking about that with a couple employer attorneys the other day for the Front Range, and we had a couple questions like, what do you do with that employee who just at 4:56 walks out and is like, see ya? We are required at separation to provide this. Now, I would look at it similar to the last paycheck. You know, last paycheck, if the employee is terminated, you've got to have it ready. And yes, I know there's a whole bunch of exceptions and all those kind of things, but generally you've got to have it ready at the time of termination. I would have this information ready as well. Now, if the employee quits, I think there's an argument that, hey, they quit, I wasn't ready for this, I'm sending it out the same time I sent the last paycheck. But with the change in the unemployment statute, which allows employees to get unemployment for that benefits for that first week, will you see more people filing sooner? So it would be one of those, I would endeavor to get out ASAP as soon as possible. It's interesting, the other question that always comes up is what's the penalty? And yeah, they're not real clear on that. I'm anxious to see if the CDLE jumps in and maybe says, employer, you can't appeal, or employer, you can't do something if you don't give this to us. Because it was clearly an effort by unemployment that they thought employees were going in with too little information when they were filing claims. What was the first day of employment? I don't know. What was your last day? Sometime a couple of weeks ago.
And if you have to have proof, you almost need to have two copies where you're having the employee, the terminated employee, sign one and you retain it for your records while you're providing the document to them as well. Otherwise, they could just claim that they didn't get it.
Yeah, and then you do the thing of, because someone asked me, well, can I send it electronically? Yes, you can. You could send electronically. Problem is, unless you have a personal account of the employee, sending it to their email account at the organization probably isn't going to do a lot of good because you shut that off.
Right.
So you shut off their access. So from that standpoint, it is a big change in the law. Make sure we're complying with it. Yeah.
We do have more questions.
Okay.
So I'm just going to work bottom up. Are we able to mail this info if the employee is on direct deposit?
Yes.
Okay. Does resignation, mutual agreement, company initiated, et cetera, for separation reasons suffice, or does it need to be more specific? Like, can it be just a one or two word reason for why there's a separation, or does it have to be a paragraph?
It's an interesting, well, it does not have to be a paragraph. Like you could say performance reasons. That's a legitimate basis for termination. It's one identified in the unemployment statute. It's one of the reasons why I like using the checkbox in the unemployment statute, because those are really short and they've got them down to like a couple of words. So I think you could just grab something from there or set up a checkbox where you just check that this is the reason for termination, insubordination, tardiness, whatever.
And would it be sufficient to mirror the language in your standards of conduct in your handbook?
I think it's, yes. I think that's super sufficient because that would then tie in that basis for termination back to your handbook. I'm a big fan of using that standards of conduct policy as a basis for all terminations. Because it's basically, for most of us, that standards of conduct is pulled from the unemployment statute.
Okay. And then, I don't know, I'm curious if you have an answer for this one. How does this apply to a staffing agency?
Oh, so when they lose I do not know that there are any, if an employee loses, it's really broad. So when an employee, if you have an employee at XYZ Staffing and they lose a job at Bechtel and Santo firm, that would be something that one of those two organizations needs to be sending that information out to the employee. Probably coming from the staffing group. That's a really good question. I think I know who this is. That's a really good question. You're not allowed to stump me on that one. So yes, good question. I look at it as required. There were no exceptions to it that I saw and don't recall any off the top of my head. But it will be, as I said, oh, this one's signed. So by the way, this one went into effect May 25th, May 20-something, in May. So start doing it.
I mean, the conservative answer would be, don't, assume that the employer, the place of work is taking care of it.
Yeah.
The staffing agency, just make it part of your
whatever notice or part of,
Yeah.
You'll definitely want to get that information. If there's any chance they're going to be filing unemployment benefits, and even if they're not, you got to get it off to them. Even if you know the person's leaving you for another job and you think, they don't need it, they're not going to file, you got to get this information over. This is the one I put in here. Yeah, I have it under the title of unemployment comp 22-234, but it's really a change in the regs that occurred back in October of 2020. We have to give employees about the availability, we have to give them the contact information to file a claim, information that they'll need to file a claim, and the contact information as to where to check the status. Yes. For those of you who have a workers' comp policy, either in your handbook or or on the board, on the wall, this is going to be a change, or this is a change, because the governor's already signed this, that we are changing our period from 4 days to file workers' comp to 10 days to file workers' comp. And there's language in here about what happens if we don't. For those who are interested, we've already written up a policy on it. So if you want it, just shoot me an email, santo@bechtelsanto.com. Everybody likes to make me plural. There's only one of me, so it's just Santo, not Santos.
I get that too, Jacob.
Yeah. There's only one of me. And so I had actually someone the other day email me, said, I'm trying to get a hold of you at santos@bechtelsanto.com. And I said, Bob, you must think we have a really big firm to think we have a Santo and a Santos. Yeah. But we don't, it's small firm still. So we've got one at the ready if you're interested, but it is a change in the workers' comp that we are going to require, or we are going to give employees now 10 days to submit that in. And there's information in your materials about occupational diseases, which is 30 days. And so we've got that information in your materials. Make sure you're incorporating. I expect, the new Colorado poster will have it as well. I expect if they haven't, and I haven't seen it, but I expect Pinnacle will be coming out with new information as well. But certainly something to make sure you get changed on your thing. Signed by the governor March 24th. Becomes effective September 2022. So we're not there yet, but we're endeavoring to get our policies changed ahead of time. This one has not been signed by the governor yet, so we're still waiting. At least I didn't see it signed. Just a number of different things, changing the reporting requirements of active medical treatments. There's also information in here about protecting mental health conditions about workers' comp recipients. So there's a lot of big changes we're anxious to see, but it wasn't sent to the governor, even though it was passed on May 10th. It didn't actually get to the governor's desk till June 6th. The mail must have been slow those couple of weeks, and so we have a little bit of time for that. So way back, how am I doing? I'm good. The way back in the beginning of COVID, we came up with the FEW law, which is the Public Health Emergency Whistleblower law. It protects individuals who suffer an adverse action, who express concerns regarding any reasonable concerns about workplace violations of government health or safety rules or significant workplace threats. That related at the time, as you see in that last provision, related to a public health emergency. And as we've now had a couple of years on that, suddenly people thought, you know, that should really be anything. It shouldn't just be just a public health emergency. It should be any government health or safety rule. It should be any significant workplace threat to health or safety, even if it's not related necessarily to the public health emergency. That is going to change. I got the information in there on that. So there's not anything you need to change with your policies. It is just an expansion of FEW law, and so be very careful with that. FEW also covers contractors. So for example, maybe you heard Manon and I talking earlier, and I said, does the room seem slanted? And if I looked at that as a workplace safety concern, because I'm concerned that now I'm going to trip as I walk up, I don't think it really is, it's just my vision. But if I did think, and then she says, you know, I don't want to work with Michael anymore. He brought up on camera that we may have a slanted room. And that FEW actually protects contractors as well, so not just employees, so something to keep in mind there.
So I know they have a poster for this. Have they updated that? And we need to make sure that that's printed, the new version is printed and posted somewhere on site?
I don't think it's been signed by the governor yet, so we've got some time on that one. Generally should be going into effect, I think it's September. Oh, here we go, check here. I did forget I put the link in there, so that's where it is. Make sure you're getting that new information out. Here it is. It passed the Senate in, where is it? Passed Senate in March. No, it's not moving its way through. That's wrong. Why didn't I change that? It is through the Senate and it's on its governor's desk. Sorry for that oversight there. Last big one, and this is a big one for those of you who use those wage audit agreements to tell an employee, I'm going to pick on Manon again because she's here, hey, if you leave the organization, I'm going to take up to 10 days after you leave. I'm not going to pay you your final paycheck at the time of termination. I'm going to wait 10 days to figure out if you return everything. You got that computer here. You got a credit card. I want to make sure you're not charging things on your way out the door or those kind of things that don't show up for a couple of days. So I'm going to hold on to your last paycheck. And then what I'm going to do is I'm going to pull that money, to the extent it doesn't violate federal wage and hour law or state wage and hour law, I'm going to just pull that money from your last paycheck. Would you sign right here to allow me to do that? Now, most employees aren't going to sign that on their last day of employment. So many employers put that in the first day of employment. You put it with the I-9, you put it with the handbook. Don't put it in the handbook. You can reference it, but it needs to be out of the handbook when they sign. So many employers will have that right. Well, apparently too many employers were using that right. And they changed it to allow employees to, in essence, understand the deduction, to be able to contest the deduction, to perhaps say, whoa, you were serious about returning the computer? I'm going to here's the computer. They've changed it so that you can see in here, it's up to 14 days, so there's a whole new change, and we also have a new agreement on this, for those of you who want to email me that. But they're changing their rules, so if you have one of those, what we've always referred to as a wage audit agreement, those 10-day delays, so you can pull money, there's a whole new procedure. You gotta give the employee notice of the deduction. You can take it, but then if the employee contests it, if the employee returns the equipment, then you've gotta give the money back. So it's a whole bunch new rules, because I think they thought maybe employers were using that without employees having any way to really contest it. They had to go to court to contest it.
How does that play in with Colorado's law that you have to provide, especially, you know, if it's an involuntary termination,
Mhm.
somebody leaves, you know, quits, that you have to get them their final pay within 24 hours? But now, if you have this type of agreement, you can wait 14 days for that?
You have this type of agreement, you can wait 10 days, and then, no, pay the employee that you abducted them out within 14 days, I'm sorry. No, time out. It's 10 days in the agreement,
Okay,
and you can delay. You don't have to pay him at the last paycheck anymore. Then the employee has time to contest that 14 days.
okay.
So it creates an exception to the pay upon termination
Mhm.
part of the statute.
Okay,
So, I mean, a lot of employers I knew were doing these agreements simply because they wanted some leeway.
mhm.
Like, I got a small business, I'm not sure I'm gonna be able to get your paycheck up and going upon termination. So they were using these wage audit agreements to buy them 3, 4, 5 days. Another way to do that, because I just talked to an organization about this a couple months ago, place an employee on unpaid suspension. Man, you know, we think you violated X, Y, and Z. We're going to put you on unpaid suspension today at 11 o'clock, the 16th of June. You're gonna be on unpaid suspension until Monday, when we're going to terminate you. Well, I'm terminated now, so my last paycheck. No, you're on unpaid suspension now. Don't do any work, and we're gonna pay you. So that's another way to kind of delay that payment of the last paycheck. But I think the wage audit agreement is a lot better, but it does have a lot of these provisions now that require the 14 days notice, and those kinds of things.
But it can't just be an additional paragraph in your handbook, and they sign the whole handbook and you refer back to it. It has to be an additional agreement signed
Yeah.
by the employee. Okay.
I don't like putting in, I mean, I like referencing in the handbook. I don't like putting it in the handbook because it says in the statute an agreement. And of course, the first page of nearly every handbook I've ever read says, this is not an agreement. This is not a contract. And so from that standpoint, you're identifying up front your handbook as an agreement, but the statute wants this wage audit thing to be an agreement. So that's why I think it needs to be separate and apart.
Okay. Yes.
Okay, that's that. Oh, by the way, just a couple seconds left here. If you're keeping your wage records for 6 years or 3 years, move that up to 6. A couple court decisions that just came out are looking at these claims for 6 years, so it's important. They don't have to be hard copies. You can electronic them. Is that a verb? I don't think that's a verb. Store them electronically, but you've got to go now go up to 6 years on that. In case you don't know, remember last year we had the now have to pay out vacation. Colorado has changed that. Colorado Department of Labor has put out an interpretive notice that basically said anything that, and this means PTO, it basically is going to cover a PTO policy. PTO now must be paid upon termination. So last year we got vacation needed to be paid upon termination. Now we get PTO needs to be paid upon termination. A new change just went into effect January 1. And my question I ask at the bottom is does that mean if we have HIFWA under PTO, we need to pay it out? Since HIFWA says we don't need to pay it out, you probably need to pay it out. Because the way they're looking at PTO, they're very broad in that usage. and you don't want to get into a problem. So make sure you're paying PTO and or vacation out upon termination. Final thing is, a lot of things on the Wage Act here, and you'll get all this material. As Manning's group talked about, Colorado FAMLI is a-coming, and there's a case, if you want to keep track of it, it's called Kronos Builders at the Supreme Court. The Colorado Supreme Court accepted a direct appeal, so that's why we expect it to be within the next couple of months as to whether or not. Otherwise, come January 1, we're going to start making withdrawals. CDLE is getting some more and more information, and they're doing a lot of information talks. I know we had them at our talk, you had them at a talk. They're everywhere. They're doing a big, for Colorado COSHRM, they're doing a big talk in October. So make sure those of you who are interested, those rules are coming fast and furious.
Right, and I know they're still developing a lot of the technology, how they're going to do the reporting, how all of that is going to work. So there's just not answers for those yet because
sometimes it is.
Yeah,
And that was my joke when I asked them to speak, is I got tired of telling folks they haven't really quite decided all that yet. They're getting closer. I saw them in October of 2021, and they seem to be a long way of those answers came up quite frequently. Now they seem to be a little closer. The other nice thing that attending talks, the one we did, I unfortunately didn't get a chance to attend yours, but ours, they said, ooh, that's a good idea. We're going to look into that.
Yeah.
So they are listening to us in this implementation. So make sure if you've got concerns, you've got questions, you reach out. They've got a whole group that's handling those.
Yes.
I'm over. So thanks so much.
Yeah, thank you for your time.
Yep.
He was afraid he wasn't going to have anything to talk about today, and here we have lots of questions.
I was.
So, I know I took some notes, and we're going to be sending out some follow-up webinars on how to manage all of this in our software. So for all of our auto paycheck clients, be watching for those. We'll follow up there. And it sounds like we need to do another webinar in August with Michael. So be looking for those.
Yeah, with the security.
Yeah.
That'll be interesting. And then, of course, we'll start doing those I'm sure with you guys with FAMLI when that starts coming. So thanks so much, everyone. Stay well. Take care.
Thank you.